Welcome to Legal Studies, and today we're going to be learning about the factors to consider when you decide to initiate a civil claim. So where are we in the study design? Here we are here. We're just starting our next heading, which is about resolving a civil dispute. So all of these dot points here that we're going to start learning about, they're all about what happens when you make that decision to sue someone. What is the journey from the first step all the way through to the end? And so what you're going to be looking at today is that first step. When you're making that decision, to sue someone, what should you think about? What factors should you consider? And there's a handy acronym to help you remember it. There are 5 factors that you need to consider when deciding to sue someone. The costs that might be involved, something called the limitation of actions, which is like a time limit, enforcement issues, so whether it, even if you win, whether or not it's actually going to be paid attention to, negotiation options, so alternatives to going to court, and scope of liability. So that's who should be sued. We got this acronym here, CLEANS. That can help you remember what these 5 factors are. So the first one, cost. This is pretty obvious. Before you decide to sue someone, you should do a calculation in your head. How much is it going to cost you, and is that cost going to be worth what you're going to get out of it? So, for example, court filing fees can be expensive. In the magistrate's court, it's not too bad, between $100 and $600. But if you're going to the Supreme Court, just to file the paperwork with them for your case, depending on the type of case, can cost up to $4,000. You may not have that money, so it may not be worth going to court. And beyond that, the general rule is that if you are successful, then the court will order that the losing party pays your legal fees, which means conversely, if you fail, you are at risk of having to pay for the other side's lawyers' costs and legal fees and things like that. So that's a cost to keep in mind. Same thing with the jury. Now, in a criminal case, you always have the right to a jury. In a civil case, you actually have to make a decision whether or not you want to have a jury. And if you decide you want one, well, you got to pay for one. And the daily jury fee can be between $500 and $1,000, depending on how long the jury trial is going to be. There's also the costs of alternatives, like if you go to mediation or something like that instead of going to court, it's going to cost you money. Some mediators can have a fee between $2,000 and $20,000 a day. So this stuff can add up really quickly, and you got to think about that before you decide whether or not you're actually going to pull the trigger and sue someone. The second thing you need to know is the limitation of actions. The limitation of actions is the time limit. Now, every civil case has a time limit, and if your case happened, if the thing you're complaining about happened before that time limit and the time limit has run up, you can't sue them anymore. So, for example, personal injury negligence cases is a 3-year window from the moment you first realized you were harmed. So you first realized you were harmed means if, for example, you got asbestos in your lungs 20 years ago and the doctor has only diagnosed it 2 years ago, you're still within that 3-year time limit because you only discovered 2 years ago. And then defamation cases, another example for you, you have 1 year from the date of the publication of that defamatory comment. You've got 1 year to sue that person. Now, the reason we put a time limit on these things is, the longer we wait before we sue someone, the more evidence is lost. It can make it really hard to defend yourself if it's too long in the past, that sort of thing. Next thing to think about is enforcement issues. And this means even if you win, you have to think about whether or not the defendant's going to even be able to pay you or whether they're going to be willing to pay you, even if the court tries to force them to. So if you've got a defendant who's bankrupt, even if the court tries to force them to pay, if they got no money, they can't pay, right? So what's the point of suing them? If they're in jail, again, they're not likely to have any assets to pay you, even if you win. The location of the defendant, whether they can be contacted, or whether they're likely to be able to run overseas and the court is not going to be able to go after them. So even if you win, if they're able to fly away to another country that, we can't get to them there, well, then what's the point of suing them, right? So you've got to think about whether you can actually enforce what the court tells you. Then you should think about negotiation options. Other than going to court, because we know that going to court costs a lot of money, are there other options available to you? Should you go to a mediator and try and work it out in a more informal, flexible way? Should you try and negotiate with them directly? Should you use some of these other services like Dispute Settlement of Victoria can offer free mediation conciliation services? So how are you actually going to approach the problem? Is court the best choice, or are there other negotiation options available? And then finally, we've got the scope of liability. The scope of liability refers to who should you sue? Who's the best choice here? So now, obviously, there's going to be one person, or at least one person, who's directly harmed you in a civil case, but there may be other people who are better decisions in terms of who you should choose to sue. So, for example, if a teacher just stands by and watches while another student bullies you and beats you up, you might be able to sue that teacher for negligence, irresponsible behaviour, not supervising properly. You might be able to sue the teacher, but some better options might be the school or the Department of Education. So making smart decisions about who you should choose to sue is something you should consider right at the start of the process. All right, and those are our 5 factors to consider. Remember our acronym: CLEANSE, cost, limitation of actions, enforcement issues, negotiation options, and scope of liability. And that's it for today.